So I'll start the special planning committee meeting. We have a quorum. So first item, that's a good question. Are there any indications of pecuniary or conflicts of interest? No conflicts. I'll open the item for discussion. And Mr. Noy, would you like to just explain what's happened, and also elected members will be aware of the memo and information that was sent through?
Yes, thank you, Chair. Look, we've had to effectively recommit this application because we became aware of a further representation that didn't initially show up on our system, and so to ensure that we've fully considered, or the committee has fully considered all the representations, we have put the matter back before committee.
Right, okay. Any questions? We might. Go ahead.
Thank you. Look, what's the difference in the reports?
Might refer to
the issues which have been raised are similar to the ones which have already been raised. I spoke to the representative and extended an invitation for him to make a deputation, and he was satisfied that the issues that the committee had previously heard from were...
So no difference. Officer's recommendation is the same.
That's correct.
Just a question. My question, which was sort of answered in the memo, was why can't we just tie it to the applicant? And it seems to me that there is some ability to do that, and whether the applicant had told us that he was going to intend to reside there, was it 4 days a fortnight? And that to me seems like a unique circumstance which wouldn't apply to some company or some applicant who just applied for the whole wanted available 7 days a week. Would that, in anyone's learned opinion, is there any problem on suggesting an amendment that's tied to the applicant because of the unique circumstances of the applicant?
Baby?
Through the Chair, the Director and I did discuss this with Ms Turner, who's the legal officer who prepared the section on this that particular issue, and she was of the view that it wouldn't be appropriate in this circumstance for the permit to be tied to this specific applicant.
But that's not what your memo say. It goes through the particular cases, and it gives you an opportunity in those particular cases that if there's unique circumstance of the applicant, then it could survive a challenge.
Through you, Chair, I think my understanding is that while there may be limited circumstances where that is a feasible option, it's quite a limited scenario, and that would necessarily could be challenged through the appeal processes. I'm repeating the comments that Ms Turner's made to us, that she doesn't think it would be appropriate in the circumstances.
But the memo doesn't say that. The memo says it's whether a person has particular capacities or aptitudes which directly relate to the use of the land. In this case, the residing for 4 days a fortnight, to me, is a particular capacity or aptitude. And it may be that the representatives might think that's okay. If it's just tied to the applicant when the applicant sells the property, then the permit disappears for short-term accommodation.
I mean, you could... I suppose the officers have indicated that there is a risk with that if it is the view of committee and council that they want to accept that risk and test it, then it's...
Well, the risk is that it could be overturned on appeal. Is that the only risk?
That's right.
There's an opportunity to have a win-win situation. Applicant's happy. The representatives, at least in 2 emails I've got, have no problem with the applicant. They just didn't want the property to be turned permanently into short-term accommodation. But if you tie it to a particular individual who has particular circumstances and capacity, and then I think that there's a risk. But the risk is it could be beneficial to everyone.
So we haven't had anybody move the motion. Did you want to move the motion?
I'm happy to move the motion of approval with that as a condition, that it's tied to the applicant because of the particular personal capacities and attributes of the applicant. And if you need to tidy that up because the applicant has indicated he will reside there 4 days a fortnight, fly in, fly out worker, I think that's a particular attribute that wouldn't apply to anyone who's just applying for it.
And for what sort of period
I
of time?
think it's got to be 2 years, because within 2 years you'd be able to see whether that worked or not.
So that would mean it would be reviewed.
In 2 years.
The application would be reviewed in 2 years. Can we do that, Mr. Noy?
Through your chair, would need to be a new application. So if it was limited in time, then the permit is limited in time, and
yes.
you need to reapply.
Yes.
To seek.
I think in the fairness of to see whether it works or not, whether there's any complaints, tying it to the applicant, we know if the applicant might sell the property, it would die with the transfer of ownership, I presume, or that it would. So I'm happy to move the thing, and hopefully that's a compromise that the representatives will be happy and the council will be happy.
Thank you. Councillor Harvey.
Chair, could you just confirm, through you to the director, I understand in the memo, I think it said that there'd been no complaints reported to council, but is that a product of people complaining not to council but to the body corporate that haven't found their way to council? So if there's been complaints to the body corporate that we haven't been made aware of, we need a process that's better than reporting to the body corporate if it doesn't make it through to council.
Through you, Chair. I did speak to a representative of the body corporate who said that there had been complaints to the managing organisation of the body corporate. There hadn't separately been made complaints to the council, and I think the understanding of at least some of the owners or occupiers was that by making a complaint to the body corporate, then that was sufficient. And I explained the difference between the body corporate rules and the council's monitoring of the planning permit. So that is a possibility that there were complaints, they just weren't notified to the council.
So do we have an idea of what those complaints were? Has there been anything subsequent that's come to council?
Through you, Chair. So I had a discussion with the body corporate representative over the last week or so, and there haven't been any complaints, as far as I'm aware, that have been made since then. Does that answer your question?
I mean, we don't have those complaints. We don't know the nature of those complaints, I guess is my question.
No, that's correct, we don't.
There has been complaints, and the tenants assumed that reporting it to the body corporate was enough, was adequate. That doesn't seem to be the case.
Based on the comments that were made to me.
Further discussion? Alderman Barakis.
Chair, and look, I tend to agree with Alderman Briscoe. I think if there's I think if the applicant, he indicated during the last committee meeting that he was didn't have a problem with those conditions being put on the application. I think if there's an appeal to a decision to approve this with conditions, I think the appeal would be in regards to the actual approval itself and not so much the conditions. I think the only person who'd ever have a problem with those conditions would be the applicant, and he seems to have indicated that he's okay with that, so long as if it implies an approval. I would ask Alderman Briscoe, as the mover of the motion, last time this was discussed last week in committee, there was talks of some other conditions about ensuring that there was a point of contact residents to raise any complaints or raise any issues. And I think can we get them read out, and I'll ask if Alderman Briscoe would happily include that, because I think that might go a bit of a ways to help mediate the process.
Yeah, I'm happy to do that, and we had a fair bit of discussion at the last meeting about
Yeah,
that,
yeah.
yes. So those conditions that amendments that we suggested last time, I think should be included as
I
well.
don't think everybody was here, certainly
can we-
the Lord Mayor wasn't here and
Oh.
Alderman Thomas, so
The,
perhaps it might be useful to
the committee were
review
here.
those.
Yeah, through Chair, Mr Banks might be able to. Oh, you haven't got them. Okay, Miss Avy's pulling up the minutes that actually had that wording at the time, so we'll just check that. So condition PLN 18, a further point, which will be point 5, to read as follows: to provide a contact number in the case of issues that require resolution.
Further, Lord Mayor and then Councillor Data.
Thank you, Chair. I just want to ask a question. With regards to the process, will this be in harmony with what we are doing, or is there going to be a breach of the process if you're going to attach this to a particular person?
With this condition, you mean?
Yeah, with this condition.
Well, it's the officers have raised concerns. Clearly, Alderman Briscoe has indicated his preparedness to accept that there are particular circumstances with this application that would justify the imposing that condition, stipulating the limitation to the applicant. What the officers are saying, there's a risk associated with that, but clearly you've heard Alderman Briscoe's position that risk is limited.
Data, any further questions?
Just one further question. So when we're talking about risk, what is the degree of risk we're talking about?
Well,
Answer that?
yes. I mean, the risk is that it's challenged before the Planning Appeal Tribunal as ultra vires. Now, what we've heard today is that some of the representors would be comfortable if it's limited to the applicant, based on what Alderman Briscoe has indicated. So, if they were to challenge the approval, it wouldn't likely be on the basis of that condition, is what I'm hearing.
Thank you.
Lord Mayor?
I'm sorry that I'm coming in on this a little bit without being part of the previous discussion, so I'm sorry if this has already come up, but just because I'll be voting on it later. The Planning Directive number 6, I presume you've sort of looked through all of that, but I'm just a bit confused because the residents have raised with me the question that under the Planning Directive number 6, section 3.3D, the use has a floor area of not more than 200 metres. So this one is under that?
No. So if you read that directive, it talks about permitted and discretionary. So it allows that to be the use to be over that uncertain circumstances. My recollection of that provision.
I thought it said that basically it's not allowed in the Wapping area if it's more than, not more than two. They have a strange way of describing things. Not more, has a floor area of not more than 200 metres per lot, and therefore it's not. And also in this same section, well, it's actually 3.3E. It also talks about the Wapping area And for some, it seems as though the Wapping area has slightly different rules around it, but it shouldn't be located in the same site as a dwelling providing long-term residential accommodation as a separate ground level pedestrian access to a road.
Yeah, I think you need to, I'd refer you to the report that goes through in some detail the response to those provisions. Assessed correctly. Now, just bear with me, I'll refer you to the section.
Page 18.
And it talks about unless it has a separate ground level pedestrian access, there is an existing mix of uses on the site. Now there are existing mixed uses on the site.
What ones?
There are other visitor accommodation units.
I don't think that's the intent of the law, is it?
I'm not sure on what basis you're...
Well, it would say unless there's existing visitor accommodation on the site, if that's what they were intending. I mean, I think...
Well, no, that mixed uses on the site. So there are residential uses and there are visitor accommodation uses. That constitutes a mixed use site.
But how about the first one that got approved? Was that didn't have separate ground level access either?
No, and that would have been under the, as far as I'm aware, original directive. There's been some changes to those directives. It is a little bit complicated, but because there's been some shifts in the directive.
Okay.
Mr. Noy, just could you just describe how this is tested against the planning scheme amendment 19 in relation to residential communities?
Well, this is under the Sullivan's Code planning scheme.
Ah, so it's not the.
Yeah.
It doesn't fit for the. So those standards don't apply in Sullivan's Cove?
No.
But,
Okay,
but
that's
Chair,
bad luck.
sorry, can I just mention that under this planning directive number 6, it does say that in Wapping there shouldn't be visitor accommodation, must not cause unreasonable loss of amenity, increased noise, something respects the character of the area. I mean, they've obviously put in place quite a lot of protections, and we are getting representations that is indeed what is happening, and that's sort of what we should be considering in a way, isn't it? Or
Yeah, and look, the officers have considered those matters, and we've concluded that in terms of noise, that we don't believe that necessarily a visitor accommodation type use would necessarily result in unreasonable levels of noise. I mean, you can have a situation where a permanent residence can be associated with unreasonable level of noise. So we don't believe that it's an elevated risk in itself.
and what was that based on, that belief? Was it research or surveys of residents, or how did you come to that conclusion?
Yes, we have had complaints in relation to visitor accommodation, short-term visitor accommodation, as we've had complaints with noise generated from permanent residents.
Right. Any further discussion? Just have another question. I believe that there's at least another application for visitor accommodation in this facility. I think it, probably next door to this one. Do we have any others that we know of that are coming up?
I'm aware of number 51, but I'm not aware of, I'll just double check the report. I beg your pardon. So I'm aware of 51 and also the report refers to 35 Collins Street. So there are 2 pending at the moment.
And 35, 135.
I might just, there was a referral to the 200 square metre floor area. That's the, as I said, the proposed includes the change of use to 160 square metre unit. There is clause 3.3D of the scheme that has a total of 200 square metres of visitor accommodation use per parent strata lot. Now, where you exceed that, it becomes discretionary. And this is a discretionary application that we're considering here today.
Okay, if there's no further discussion, we have the motion which has those amendments from Alderman Briscoe. So I'll put the motion. Those in favour?
Aye.
Those against?
No.
Show of hands. Those in favour? And those against? Okay, so the item is the motion is lost. Have we got a?
I'll move for refusal. And I think we had some words from the previous meeting. If we could hear those again, please.
Thank you. Sorry, Mr. Banks, could you go to the microphone, please?
Sorry, Chair. That Assured Planning Directive number 6, exemption of standards for visitor accommodation and planning schemes, clause 3.3e. The council refused application for change of use visitor accommodation at 53/1 Collins Street, Hobart, for the following reasons. The proposal does not satisfy subclause 6 because there is an unreasonable impact on the amenity of the long-term residents of 1 Collins Street.
So, do we need any further discussion, or happy to just to put the motion? Okay, so I'll put the motion. Those in favour, say aye. Aye. Those against?
Aye.
Show of hands again. And against? So the item is tied. So, pardon?
The item would be referred to council without recommendation to the City Planning Committee, Chair.
Thank you. Thank you. Meeting closed.